We have stock and we're getting divorced. I have some stock on my side of the equation. I've invested in different publicly traded companies, and my spouse has done the same. What happens in a divorce? We're going to value that asset, keeping in mind that during the course of the litigation or the mediation, that asset is either appreciating or depreciating, and my spouse is along for the ride. So if I have a stock that soars during the course of the divorce, my spouse is on the ride with me with that stock, and my spouse would receive their fair share of that now newly grown stock. Can I do a little divorce planning? What if at the start of my divorce, I sell every stock I own, I then have that money sitting in the bank, and I proceed to spend it during the course of the litigation? Can my spouse argue that I dissipated a marital asset? Yes, dissipation is a term of art in a divorce, or in any case for that matter. My spouse could readily argue that that asset existed the day I filed, and I purposely liquidated it and then spent it during the pendency of the case, and my spouse could ask to be made whole at the conclusion of the case. Stock options. There are many schools of thoughts on stock options, and great minds can offer differ on how we divide stock options. But in general, we look at what options were granted during the course of the marriage, irrespective of when those stocks actually vest. So if I was granted shares of stock before I filed my complaint for divorce, my spouse is entitled to a share of those stock options when they vest, and even though they could vest after we're actually divorced.